Hello, everyone. My name is Cheryl Thomas, and I'm with Global Rights for Women in Minneapolis, Minnesota. And I have with me here today, I'm delighted to introduce to you Magistrate John Shulte from Duluth, Minnesota in St. Louis County. And I'm going to tell you just a little bit about myself and our organization, and then I'm going to let Magistrate Shulte talk to you a little bit about his background, and then we'll get into the subject matter that we're discussing, and that is the issuance of civil orders for protection in civil courts during the COVID-19 crisis. So Global Rights for Women is a nonprofit organization in Minneapolis, and we do work both locally and around the world at the invitation of partners who are interested in improving their laws, policies, and practices, and learning about systemic reform on violence against women and girls. Much of our work is about domestic violence, as that is the most common form of violence in the world today. And we are doing trainings and consultations and capacity building, as I say, at the invitation of partners who are interested in just building capacity to make sure that their legal systems are as effective as they can be in promoting victim safety and offender accountability. So Magistrate Shulte, I would love it if you would introduce yourself and just tell us a little background about yourself and then your role in domestic violence cases and civil court there.
Certainly, thank you. I'm very happy to be here. My name is John Shulte. I'm a court referee or magistrate judge, again, chambered in Duluth, Minnesota, a city of about just under 100,000 people in northern Minnesota. There are 8 other judges in the courthouse where I work along with myself. I've had this position now for about 6 years. Before that, I was an attorney in private practice for about 15 years. Practicing primarily in family law, mediation work, and I also did some part-time work as a guardian ad litem. In my capacity as a referee, I hear small claims court cases, eviction and housing court cases, family court matters, and most relevant to our discussion, I preside over about 95% of the harassment and domestic abuse order for protection cases that come through our courthouse. It's challenging work, but I've been doing that from the beginning. And again, I've been on the bench now for just under 6 years.
Okay, so you have heard a lot of civil order for protection cases, both through the emergency order application and then the longer term order?
Hundreds, if not maybe even low thousands. Yes, it's been many.
Would you tell us just a little bit about St. Louis County and Duluth, just to give our listeners an idea of your context? Is it rural? Is it kind of the population?
Sure, and Duluth is what I would call a smaller city. Again, the population is just under 100,000 people. So I would say it's relatively urban by northern Minnesota standards anyway, but the county itself goes all the way up to the Canadian border. So there are parts of St. Louis County that are very remote and very rural. St. Louis County is a little unique in that it's one of the only counties in the state with multiple courthouses because it stretches for 100 miles. There are actually some judges up in a couple other towns, Hibbing, Minnesota and Virginia, Minnesota, have their own courthouses with their own judges. So I travel up there once in a great while, but that's pretty rare. I actually work for what's called the 6th Judicial District, which if you look at Minnesota is the entire sort of northeastern part of the state, including along the entire north shore of Lake Superior. It's beautiful and it's very cold.
It's about 2 hours north of our capital city, metropolitan area, St. Paul, Minneapolis.
That is correct.
Okay, sounds good. Is it a diverse population up there? I think that's important for folks to know.
No, not particularly. I mean, demographically, Duluth is mostly white. We actually do have, I also preside in Carlton County, and there is the Fond du Lac Indian Reservation is located there. So we actually do have a fairly substantial Native population in the area compared to some parts of the state of Minnesota. So to the extent that it is diverse, that's probably our biggest demographic.
Right. So you'll be issuing orders for protection there too, then in the Native population?
Absolutely. Yep.
Okay. Sounds good. So tell us about the services that are normally, in pre-COVID times, I should say, available for domestic violence victims in your court.
Well, in our court, so the actions again I preside over are harassment restraining orders and domestic abuse orders for protection. The difference is to file an OFP, there does have to be a qualifying or domestic relationship between the parties. So either they have a child in common, they're a romantically involved couple, blood relatives, folks who've resided in the same household for at least a reasonable period of time. There has to be what we call that domestic relationship to file for an OFP. What happens is somebody who claims to be the victim of domestic abuse fills out a petition, many times with the help of an advocate, files that petition basically asking for a court order that makes it, if the order were to be violated, a criminal offense for the perpetrator of the abuse to have any type of contact with the victim of the abuse. And the big thing about OFPs and harassment restraining orders and what makes them important is to violate them is a crime. To have one put against you, it's not a criminal proceeding. And sometimes I have to explain this distinction to folks. But if you have an order against you and you are found to have violated that order, that's an automatic arrest. It's generally being held in custody, and then it's a crime. The first offense is a misdemeanor, but if there are subsequent offenses, it can be a gross misdemeanor and eventually even a felony level offense for somebody where there are continued violations. And these are orders that can be put in place for up to 2 years. And if there are some very unique circumstances, occasionally up to 50 years. That's rare, but 2-year orders are very, very common.
And when is a person entitled under law to get that 50-year order?
If there's been, they've had 2 other orders in the past against that same person, or that person has at least 2, I believe it's criminal offenses, convictions with that person as a victim, then you can ask for relief for up to 50 years, and the respondent isn't even allowed to ask that it be modified or changed until after, I believe it's 5 years.
And
those are rare though.
Okay, that was an amendment that occurred under our law not too long ago, right?
Yes, that's a fairly recent development.
And
but for our purposes, probably 2 years is generally the time period that's relevant.
Okay, the idea behind that 50-year order is just to make sure that victims don't have to keep going back to court and getting orders renewed. Is that correct?
That's correct. And orders can be extended. There's a procedure where an order, after, if it's coming up on expiration, can be extended, usually for an additional 2 years. And the threshold for an extension is less than what somebody would have to show to get an OFP put against or put in place in the first place.
I see. Okay. You mentioned just a minute ago that the violence victims have access to advocates to help them fill out those applications.
Correct.
Am I right about that? And can you tell me how that works?
Yep. In Duluth, we have an organization called Safe Haven, but there are a number of organizations, as you know, throughout the state of Minnesota that provide advocacy services. They answer questions, they help complete paperwork, and in many instances, they actually come to the court hearing with the victim and sit beside them at counsel table. They're not allowed to be full participants in the hearing or question witnesses because they're not licensed attorneys, but they're there to provide support, to answer questions, and advocate and sort of be there for someone.
And why is that important, do you think?
I think it's important because when a victim of abuse comes into that courtroom and has to face the perpetrator, that is a very scary and intimidating and often very difficult thing for them to have to do. And to have somebody there who's knowledgeable and experienced to be there with them and to help guide them through that process and get them through that court hearing and through that day, I think is an invaluable resource among all the other good things they do. But as far as what they do in the courtroom, it's really to help somebody get through what's a very oftentimes difficult ordeal.
Okay, so we're talking about orders for protection now. We've generally been talking about during regular times pre-COVID. Could you just comment for our listeners about the importance, generally speaking, of an order for protection versus, let's say, the criminal system's intervention in domestic violence cases? Many jurisdictions around the world are relatively new to having that remedy, that civil protection order or order for protection that's sometimes called barring order, available to domestic violence victims. Why do you think it's so important to have that?
Well, I think in part it's important because, it's a different burden of proof. To get a domestic abuse order for protection, a victim just has to show what's called by a preponderance of the evidence that domestic abuse occurred, which basically means it's more likely than not that domestic abuse occurred. As I'm sure many people know, to get a criminal conviction requires proof beyond a reasonable doubt. And there are certainly many cases where either charges are not filed or criminal charges for whatever reason are dismissed or don't stick, where having a civil protective order in place is still appropriate and provides a measure of protection that goes above and beyond what might be offered through the criminal system. Now, in some cases, there is a criminal case, there's a conviction, no contact is an enforceable term of probation, and the OFP is essentially kind of just you have two orders kind of doing the same thing. But there are many cases where for many reasons there may not be an order in the criminal case, or it may expire or go away, where then that civil protective order is still there.
Right, so they can be in place simultaneously, or one can be in the civil order for protection can be there, like you say, if the criminal case gets delayed, or she may not want to testify, and they might decide to dismiss that criminal case.
Absolutely, and one of the things that I sometimes have to explain in hearings is that they are separate, and any order that I issue out of OFP court has no bearing on a no contact order that might be part of a criminal file, that they are two separate proceedings, and even though some of the issues may be very related, they're different. In fact, there's a provision in the order for protection statute that says that if a respondent wants to testify in their OFP hearing, that testimony can't be used in the criminal case. So if they want to testify and sort of contest or defend themselves in OFP court, the prosecutor cannot use that testimony in the criminal side of things. And I think that's appropriate.
Okay, very interesting. Thank you for that. Let's talk now about how your work as a judge has shifted during the COVID-19 crisis. And we have a stay-at-home order from our governor, and we have our businesses have basically shut down in our state and around the country. So how has your role as a judge and the court process in general in St. Louis County changed during COVID-19?
Well, it's changed significantly, and of course things are happening very, very quickly and changing from week to week. But essentially the biggest change is that any cases that are not considered high priority cases have not been being heard. So obviously, I said I preside over evictions. The vast majority of evictions are stayed by order of the governor. They're not even happening. Small claims court is not happening. Only the highest priority cases with defendants in custody, and as I'm sure we're going to talk more about, certain types of domestic violence cases and a few other child protection matters, very serious cases, are the only cases that are being heard in person at the courthouse. So on days I don't have court, I'm working from home, I'm reviewing files and doing what I can, but we're in a lull right now. And of course, on the back end of this, when this comes to an end, we are going to have a massive backlog of cases that we're going to have to work our way through. And I know I will be paying a very steep price on the back end of this for maybe what little bit of extra time I have now while I'm home on days when I'm not presiding over court. Although we are starting to try to increase the number of cases we're hearing with the use of remote technology. much like what we're doing, video conferencing and things like that. We're trying to gradually expand the number of cases, but contested trials where you have to present evidence and get testimony, those kind of need to be in person.
Okay.
Oftentimes.
Yeah, interesting. So let's talk about now. We heard from another judge in Minnesota here in Hennepin County in our metropolitan area about a little bit about what is prioritized, and domestic violence cases and order for protection cases are prioritized, and that's why you are doing in-person hearings with those. And that came from a Supreme Court order, correct?
That is correct. The Supreme Court has been trying to provide direction and guidance on what should and shouldn't be heard to try to have some consistency around the state, as opposed to doing it one way in St. Louis County and a different way in Hennepin County. We want to make sure that we're treating everybody equally.
Okay, so tell us what are the cases that are prioritized then?
So domestic violence cases, when an OFP is filed, it is reviewed and is still taken in, assessed. A temporary, or what's called an ex parte order, will still be granted if that's appropriate. And if a hearing is requested by a respondent, that hearing will still be set. And if a hearing is required, that hearing will still be set. Now, I will note that as far as a prompt hearing being set, meaning a hearing within usually a very short span of time, 5 to 7 days, only cases with very serious issues that require immediate attention. That would be where their parties are sharing the same address and there's an allegation of domestic abuse. Cases with emergency custody or child issues where child abuse or child sexual abuse is alleged. Cases with an immediate safety concern where a firearm restriction is being requested because the use of weapons or firearms might be a concern, because an OFP will preclude somebody from possessing a firearm, at least for the time it's in effect. So those emergency type hearings are still being set. They're being set at the courthouse, and we are conducting them in person with, as many safety protocols in place as we can reasonably include.
Okay, so now the emergency order can actually stay in place under our law for an extended period of time. Will you just talk about that just a little bit?
Yep, so when an emergency order is signed, typically that is automatically in place until the hearing is set, which, if it's a case where a hearing is mandatory, which historically is within 7 days. Now it's only within 7 days in those emergency type cases. In other cases, the temporary order is going to stay in place until such time as the matter can be heard and scheduled, which right now I think the order extends through the beginning of May, and after that it's a little uncertain. Right. So yeah, they can be fairly long-term temporary orders.
And why do you think that's important, particularly right now during COVID, Magistrate Shulte?
Well, I think that's important because you need to, in assessing a petition, if there are immediate safety issues that require an order to be signed right away, we need to have the ability to do that so that that protection is put in place just as soon as the sheriff is able to serve that order. Because once it's served, then it's a binding order upon the respondent.
And we don't want it to expire quickly, because in some jurisdictions around the world, they expire pretty quickly, and then the abuser is free to go and free to go home, and that's particularly dangerous time.
We don't want to put anybody in harm's way or have any order that expires just because timelines run out without some action being taken.
And before you've had a chance to evaluate what the safety situation is and the danger is, and figure out what all the things you can do to protect.
That is correct. And every order for protection that comes in is screened by a judicial officer, who then makes the decision what needs to happen with that case. Should a hearing be set? And if so, is that a hearing that needs to be set ASAP?
Okay, thank you for that explanation. I do get concerned about the short period of time that the emergency orders can stay in effect in some jurisdictions, because we know so clearly how dangerous it is when women, victims of violence, any victim of violence, reaches out for help. So we, like I say, we want that order to stay in place as long as possible so that a judge can review it.
Absolutely.
Okay, so you had, we had talked with you a couple weeks ago in a webinar that we presented, and we had all been concerned at that time during this COVID stay-at-home order that many judges just weren't seeing a lot of order for protections being applied for. Now, that's changed, you just mentioned in our conversation today.
You know, obviously, when you have people who are now essentially stuck at home together, that creates the potential for some really bad situations. I think when this first started, there was just so much uncertainty, and people were just sort of trying to address their immediate, whether it's their job needs, loss of job, financial security. I think everyone was kind of in a state of shock almost. And we saw our filings really come down for a couple weeks. But now that this has been going on for a while, sadly, we're starting to see things trend in the other direction, and we're starting to see an uptick in some of the orders for protection that are filed. And sadly, of course, the ones that are filed generally involve people who are residing at the same address, which means those do need to be set for a prompt hearing, because you're potentially precluding somebody from their housing. And that's something that, you know, we do if safety mandates it, but that we also take very seriously and requires very serious consideration before we do something like that.
Okay, so in addition to these guidelines that are kind of statewide, that the Supreme Court and the governor have been giving us, you have also taken some steps yourself just to make sure that you're doing everything you can to provide victims of domestic violence safe and fair access to the courts. Can you talk about that just a little bit?
Yeah, you know, right now the courthouse is actually closed to the public. So there is a person at the entrance kind of monitoring who comes in and out of the courthouse. They will give you a very brief health screening, just ask you, are you feeling well today? Have you come into contact with anybody who you know was possibly exposed? I don't think they're doing temperature screens at this point, although that's certainly something that might be on the table. We then are holding the orders for protection in a bigger courtroom than we used to use. We used to have kind of a small hearing room. Now we're using one of our big sort of jury courtrooms, spreading everybody out as much as we can. We wipe all the tables and chairs and surfaces between hearings. A lot of times the court reporter is now not in the courtroom. We're doing a lot of remote court reporting. We're limiting the number of people in the hearing to the parties, their attorneys, one advocate, and maybe one support person who could sit, you know, kind of back in the gallery area, where before these were full public proceedings and as many people as, you know, wanted to be in there could theoretically be in the courtroom. And we're limiting that not out of any ability to not have open and transparent court, but just because safety requires it. And even then, we can't always keep everybody 6 feet apart all the time, which in an ideal world we'd be able to do. But we're doing the very best we can to make sure these important cases are still heard and address you know, the very real safety issues that sadly are going on all around us.
And you're also, I was just impressed to hear that you're also taking some steps to make sure that the victim doesn't have to be there alone.
Absolutely. No, an advocate is still more than welcome to participate in the hearing and be in the courtroom, along with attorneys, although in more OFP cases than not, the parties just represent themselves. There are not attorneys. Sometimes there are, but not always.
So it's usually the victim and an advocate and maybe a support person that you'll allow.
And then the respondent, and really sometimes there's no more than 5 or 6 people in the courtroom total.
Okay, that's helpful. Anything else you're doing to just that I've missed here to just ensure that victims of domestic violence are getting access to the courtrooms, to the remedies that they need, or something that you wish you might be able to do, or you are seeing emerge as a need as this crisis goes on?
I just hope, and I guess I don't quite know how to address this, but I hope everyone out there at least knows that many of these resources are still available and that we are here and open for business if we're needed. And that if somebody is in crisis, I hope they don't feel as if they're trapped and just forced to stay in an unsafe situation because they just don't understand that maybe these court remedies are available to them. And I guess I don't know how you sort of address that other than just getting the word out there and making sure that that's widely known among the community to the extent we can, but that we're here and we will address these very important cases if we need to. And I hope everybody knows that.
Okay, that's something I can see would be very concerning just because of the isolation that we're all experiencing. Do you feel, I'm not sure I asked you this before, that victims of violence are getting now, in addition to access to the courts and the remedies that the courts provide, are they getting the access that they normally get to the help and support of the advocate? You're allowing it certainly, but do you see in your presiding over these cases that there's difficulty for victims to get help from advocates because of the isolation?
They've still been attending the majority of the hearings that we have, so I think so. I don't know as far as their office and being able to have in-person meetings, or if they're doing a lot of things now more by phone or remotely. You know, you'd probably have to talk to somebody in that world, and maybe they could probably have some real good insight on what's happening. But as far as their attendance at the hearings, it has been about the same as it was pre-COVID, which is encouraging and good to see.
Okay, and now we talked just briefly about criminal cases. Your primary role is with civil family court orders for protection. And
that is correct.
You mentioned something about making sure it's very important that certainly violations of orders for protection are being enforced by our law enforcement and criminal courts. And do you feel like that's happening? Are you concerned about that? Are you concerned, just even from your perspective in civil courts, that abusers who violate protection orders are being released from jails?
No, I actually think that we're doing a very good job. Duluth has always been kind of on the forefront as far as, what's called a coordinated community response, where advocates and law enforcement and the domestic abuse program and that whole infrastructure really works together and with each other in a way that's always I think been very effective here. So I know that those cases are still being charged where violations are being shown. I know arrests are still being made. I know probation agents, even if they're having remote meetings, are still being very proactive and staying in touch with folks. I also know that while, and again, I don't preside over criminal matters, I know there's been a big uptick in requests to release people from jail, and even an effort, I think appropriately, to release some nonviolent folks from jail to keep those populations down. I know in the context of domestic abuse cases, that is not being done unless there is victim input. That somebody is not going to be able to get out of jail early on a domestic case unless there's some blessing from the victim for that to happen.
Okay, so yeah, that's important, and that's what we are seeing that around the country too, that and likely around the world, where in the effort to just keep this virus from spreading, there are requests to let people out of jails and prisons who are nonviolent offenders. So it's heartening to hear that the violent offenders are being carefully reviewed before that happens.
That is certainly my understanding in talking with my colleagues on the criminal court as far as what is going on, yes.
And just for our listeners, Global Rights for Women will be interviewing some criminal court judges to dig deeper into the issues about how criminal court is addressing the increased challenges that domestic violence victims are facing as they try to, as criminal courts are working to hold violent offenders accountable. So Magistrate Shulte, I'm so grateful for your time. I know you had a 3-hour in-person hearing on an order for protection. I am grateful for your insights and your attention, and really your caring about these cases so much. Is there anything else you'd just like to add before we close the interview?
Not really that I can think of. It's been a pleasure. As we discussed on the panel a couple of weeks ago, what's tough about this is I think there's some fundamental inconsistency between what's maybe best for the safety of the public as a whole right now versus what's best for the safety of victims of domestic abuse. And we are trying to just strike that balance, at least for our part in the court system, as best we possibly can. We're learning not only week to week, but day to day, because this is an evolving and very rapidly moving situation. I know even in the last month, I've become way more tech savvy than I was when all of this started. And I think that's good because it's showing us and giving us some insight into maybe some new ways of doing things that we hadn't contemplated before. So if something good can come of this, if this makes us a little more mobile and nimble and able to respond to challenges and adjust on the fly, that's never a bad thing in any organization. So maybe we can come out of this with some positives on the other side.
Right, some more innovative and creative ways to make sure the courts are meeting the needs of the people.
Absolutely. So, but no, it was my pleasure. Thank you.
Wonderful. Thank you so much, Magistrate Shulte, and thank you all for participating and listening to our interview today. Take care.
Bye.
Bye-bye.